Good morning, good morning, good morning, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and as always at stupid o'clock, we're going to that horrible world known as the JRC. But before we get started this morning, a few of the usual disclaimers. Alright, folks, first off, you are going to see the link to the law documents we are going to be going over this morning, probably for the next few days, right there in the description box, as well as the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject. Also included is the templates. Sign your name, click on your senator. Please assist us in ending aversive punishments and improper restraints in schools. It kills children every year. Also, the ever-present change.org Shut the Judge Rotenberg Center Down petition. I do believe the title is self-explanatory. All right, folks. And also, when we are speaking about the JRC, you're going to hear vivid descriptions of, as well as see clips from video surveillance footage of, peoples with disabilities being tortured and abused. If you have young children present, please, folks, go ahead and use your headphones. Also, folks, it is exactly, as of right now, 3:27 a.m. in the morning, and I have not had my usual dose of caffeine yet, even for this early. So if I stumble over any of my words this morning or start staring off into space, my apologies in advance. Alright, this morning we are going over the legal documents in the effort to overturn the quote-unquote consent decree, which is also the 1988 settlement agreement that the JRC has used as consent to continue the torture and abuse of disabled people. Now, we are going over the first part here. I'm sure it'll give me a date at some point. Defendant's memorandum of law in support of the motion under Probate and Family Court Rule 60 and Massachusetts RCIVP 60B5 to vacate consent decree. Alright, so let's go over here. Over 25 years ago, the director of the former Office for Children, OFC, issued a series of emergency orders and took other actions designed to suspend, without hearing, the license of JRC, a residential facility in Canton that provides services to individuals with intellectual and developmental disability. If that's what you all call services, I'll keep my happy ass in Missouri. And I don't even like it here. I'm stuck in the Bible Belt, but I'd rather be stuck here than dealing with that. If that's what y'all call services, I don't want to know what you do till you're incarcerated. After JRC filed this lawsuit challenging the director's actions, and of course this goes over what we've been over before, parties entered into a settlement agreement, which became a consent decree after it was incorporated as an order of this court in January 1987. The plain language of the agreement contemplated termination without approximately 1 year. Right? Yet somehow they have seen fit to continue on with it. But in 1988, this court extended the agreement because, at the time, JRC was not fully licensed. They weren't fully licensed and they were still pulling this. What does it take in Massachusetts to get you to yank a facility's license then? Somebody explain that to me. How the hell are your laws so lax? And how are you all so afraid to enforce them that you are willing to let a facility that is not even fully licensed to continue horrific crap like this? Like, what planet are you even on? JRC has long since been operating with a full license. God. But the consent decree has remained in place to this date. Today, over 25 years after the decree was entered, significant changes and circumstances have come to pass that warrant vacatur of the decree because a prospective application is no longer equitable. Thank you. God, that's putting it mildly. Mass R Civ P. First, both terms of the decree and the current facts demonstrate that the purpose of the decree was long ago achieved. The plain intent of the parties was that the decree would terminate after approximately 1 year, i.e., the time necessary to remedy JRC for FC's past bad acts. Are you kidding me? It was a horrible act for them to close them down because they're freaking torturing people and not meeting state standards for education? Really? The defendant agencies have already complied with the decree for a much longer period than the parties intended, including 10 years during which DMR was under receivership. It has now been over 6 years since the receivership was terminated, and since that time, the defendants have continued to fulfill their obligation under the decree, both by complying with its terms and exercising regulatory authority over JRC with fairness and transparency. Fairness to the JRC. What about fairness to their victims? What about their rights? What about being fair towards them? Oh, right, I forgot. We're not people, right? Vacatur of the decree is thus not only equitable, it is required under the doctrine of separation of powers, which prohibits a court from enforcing a judgment concerning the exercise of executive functions, absent evidence that the agency has refused to comply with the judgment or has broadly obligated in statutory duties. That doctrine is particular force here because the decree has for some time granted JRC remedies not available to any other provider in the Commonwealth or anywhere in the world. Anywhere in the world. They have liberties, full, complete, and utter power over every single second of their students' lives, every moment. Nobody should have that kind of power over a human being. It is absolute power. And we all know what they say about those who have absolute power. Second, current clinical and empirical evidence, which was not available when the decree was entered, reflects an overwhelming professional consensus that the adverse punitive interventions now used by JRC, primarily contingent electric skin shot, do not conform to the accepted standard of care for treatment of individuals with intellectual and developmental disability. Thank you. Thank you. Speak sense to these idiots. God. And by the way, anyone who wants to come in here and tell me, you just don't understand. You're disabled. You have autism. You don't get it. I've worked in the field, okay? I've been certified by my state, and I have worked in the field. Don't even come at me with that. This change in standard of care, which DDS has recently incorporated in its regulations to apply on a prospective basis, is in inherent conflict with JRC's position that the decree affirmatively authorizes those procedures and that DDS has no authority to regulate their use, which is insane. Insane. To continue to tell the courts and the agencies that are put in place to actually license their ass that they have no authority over you to tell you what you can and can't do with your students is nuts. Nuts. Those they're put in place for a reason, folks, to make sure people with disabilities are not being abused or harmed or starved. Not only do they help coordinate care and treatment, they are also placed there, folks, to make sure this shit doesn't go on. And that if there is abuse going on, that it is caught immediately and immediate action taken. For the JRC to have the balls to tell their state government that they have no power to stop them from their quote unquote treatment and they get away with it, JRC's position and its related claim that it is entitled to arbitrate any disputes with DDS before a court monitor have hampered DDS efforts to ensure JRC is complying with the accepted standard of practice in the field of behavioral treatment. Thank you. My God. Continued enforcement of decree would therefore be contrary to the public interest, warranting relief under Rule 60b-5. For these reasons and those below, the decree should be vacated in its entirety. Thank you. Background. The underlying complaint and decree. The allegations of the complaint. And by the way, guys, I did look up. It's from February 2013. We've been trying to overturn this shit since 2013. Think about it for a moment. JRC filed this action in 1986, seeking injunctive relief based on a series of events that occurred over the course of approximately 7 months the previous year. In particular, JRC claimed that OFC, through its director, had engaged in bad faith regulatory and licensing activities in an attempt to prevent JRC from using professionally appropriate aversive interventions on its students. You all are fucking sick. Remember what those were: hard skin pinches, spanks, using pneumonia. But those are professionally appropriate? Wow. God. At the time, the aversive techniques being used by JRC consisted of water sprays, taste aversives, muscle squeezes in conjunction with mechanical restraints. Also spanking. I noticed you left that out, and hitting people with spatulas. JRC used these techniques in lieu of any antipsychotic medication and other more restrictive procedures such as seclusions and electroshock. In early to mid 1985, an OFC employee conducted a licensing restudy of JRC and concluded that its techniques were clinically appropriate and conformed to the standards recommended by professionals in the field. Jesus Christ. You think that meets standard of care? Wow, you must really, really not think we're human. I mean, that's what we deserve, right? Despite this conclusion, a few months later, OFC's director sent JRC a notice of emergency suspension and an order of show cause, mandating that JRC cease all group care or be subject to prosecution. Thank you, somebody had some damn sense. The director also sent an emergency order to correct deficiencies, requiring JRC to cease the use of any physical aversives, cease the use of all contingent food programs, and cease intake of new students. Good, I'm glad somebody had a brain and saw this for what it was. OFC took these actions without giving JRC notice or an opportunity to make alternative arrangements for treatment. Further, OFC did not offer any offer any medical, psychological, or psychiatric evidence suggesting the existence of an emergency or alternative procedures or placements that would serve the needs of the students. Now, I think they were too busy thinking they are torturing people. We have to protect the kids. Somebody has to. Now, was it right legally for them to do that? Probably not. But I'm hardly going to fault someone for wanting to do whatever they had to protect those damn kids, since nobody else seems to want to. JRC immediately appealed the emergency suspension to the Division of Administrative Law Appeals, which found that, contrary to the OFC's determination, there was no emergency and that JRC's license should remain active pending a hearing on the merits. Shortly thereafter, in December 1985, the parties entered into an interim agreement in which they agreed to stay the DALA proceedings so that JRC could apply for variances with OFC. OFC failed to comply with the interim agreement in several respects, including by assembling what JRC believed to be a biased panel of individuals to review JRC's variance requests. Really? Really, JRC? You're going to call them biased? Really? Really? You mean the school that never lets in any outsiders to contribute an opinion on any of their treatments ever is calling them biased? Okay, Karen. OFC also asserted that JRC could not appeal that portion of its order bearing intake of new students, and it refused to participate in the DALA hearing that was convened for that purpose. In March 1986, the parties entered into another agreement, which provided for a term to be assembled to evaluate treatment plans for 18 of the most handicapped students then enrolled at the JRC. God, can we... Ugh. The parties agreed that the term would have full authority to design plans for students, and that its authority would not be affected by any decision made on the JRC's variance requests, so giving them absolute power. Thank you, court system. I'm glad to know you are here to protect all citizens. The team proceeded to issue plans that included contingent food program, physical adversives, and automatic vapor spray feature. So you all just agreed to everything and agreed to starve us. Thanks, Massachusetts. 2 days later, however, the director denied JRC's variance applications, and contrary to the plans designed by the team, banned the use of contingent food programs, physical adversive, water vapor adversives, helmets, and taste adversives. Yeah, because they have a functioning brain and knew what you were doing. The director also heard JRC from resuming intake of new students and made JRC's relicensing contingent on its agreement to radically change an approach to treatment, which they didn't. They just doubled down and got worse. Moreover, before affording JRC a hearing on license suspension, OFC contacted state and local education agencies, stating that JRC would close and urging them to withdraw their students. According to JRC, all these alleged acts showed that the OFC had abandoned its proper monitoring and licensing review of the JRC because they didn't do whatever you wanted? Really? Really? JRC asserted that the then director, in particular, had demonstrated through her actions that she was completely incapable of fairly and impartially exercising monitoring regulatory and licensing functions, or acting in the best interests of the JRC students. Really? Really? Because she saw what you were doing is torture, and she saw it for what it was. That means because she didn't do whatever you wanted, she's not being fair. She's not being unbiased. Oh my god, it's the argument I hear all the time. You just don't understand. Understand what? That you torture people and get paid millions of dollars every year to do it? I think that's pretty straightforward. Just just saying. The class and claims. Based on the above sections, JRC and the parents of two students sought equitable relief on behalf of a class of approximately 60 students then attending JRC, their parents, and their guardians. The proposed class did not include future students. The complaint raised 8 claims, 3 of which pertained to JRC. Those 3 claims did not assert any ongoing wrong, but rather sought relief solely to remedy OFC's, especially the director's, past conduct. Yes, let's not call the JRC out on their torture chambers. Counsel for alleged that OFC violated JRC's and the class plaintiffs' due process rights under the Declaration of Rights, Articles 10 and 12, but it engaged in a series of actions which were arbitrary, irrational, and unrelated to any legitimate state purpose, and outside of the OFC's statutory mandate. Why you parents insist on torturing your children for daring to exist when it was you who brought them into the world in the first place, and you only throw them at the JRC because you refuse to take responsibility? Just saying. Count 7 alleged that the director violated JRC's rights under the Civil Rights Act, GI, by depriving JRC of due process through threats, coercion, and intimidation. What the fuck? Really? Their civil rights. Their civil rights. Let's not care about the civil rights of the students or the human rights of the students that are violated with impunity every single minute of every single goddamn day. Let's not think about those students that you treat like fucking war criminals. Or the threats, coercion, the intimidation, the traumatizing, the fucking torture that they go through every day. But the JRC's civil rights were violated. Really? Really? Wow. Court 9 alleged that OFCs violated the Administrative Procedures Act GIE 30A because the director's various orders were not based on substantial evidence, and because the OFC failed to provide an adjudicatory hearing for JRC to contest the closure of intake of new students. The remaining 5 claims brought on the behalf of the class plaintiffs only likewise sought relief based on the discrete past acts of the OFC and the director. Court Count 1 alleged that the OFC emergency order to correct deficiencies and other OFC actions interfered with the students' rights under the Declaration of Rights, Articles 10, 11, and 12, to habilitation and right not to regress as a result of state action. So here we are again with this whole contention to JRC. It's for our own good and it's helping us. Really? Really? You think you are upholding a student's rights by torturing them? Can somebody explain that fucked up logic to me? Can somebody make that make sense? If we stop them from torturing the students, we are violating the students' rights. Does this make sense to anyone? anyone. uh, Tell me in the chat if that makes sense to you. Court 2 alleged that OFC interfered with the students' rights under GL 71B to educational services designed to ensure their maximum possible development. Exactly how are they supposed to develop when you all are constantly torturing them and they are under threat constantly? Make it make sense. Count 3 alleged that as a result of OFC's actions, the students have not been assured the sound and coordinated development of services, and the parents have not been able to play a decisive role in the planning, operation, and evaluation of programs for the care of their children in violation of former GI 28A, blah, blah, blah. In other words, the parents don't want to do their job and actually fucking parent. So they throw them at the JRC and then they fucking complain when the court or the department over licensing tells them you need to take a more active role in your child's life and actually look over alternative treatments. Like everywhere else in all 50 states do every single day. I know I've been a part of many, 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 many of those meetings. Okay? So the JRC and the parents don't think it's fair that what they were trying to do was make parents do their jobs, get their head out of their ass, stop thinking about themselves, and start thinking about what's best for their kids. And they're going, how dare you? They should be punished. How dare they exist? They're an embarrassment. That's pretty much what it is. Pretty much what it is. You think those parents care about what happened to those kids? The ones that defend this school? No, they don't. They don't give the first fuck. Just saying. Count 5 and 6 allege that the director violated the parents' and students' respective rights under the State Civil Rights Act. That is the biggest bunch of bullshit I have ever heard in my goddamn life. Because we wanted to protect the students. Because she wanted to protect the students, she was violating their civil rights. How does that work? How does that work? So today we have descended down into some of the most backwards, messed up logic that I have, quite frankly, ever seen in my entire goddamn life. Where the JRC and the parents that defend them use this backwards, messed up, psychotic logic to where they believe if you are actually trying to protect those students in that school, that you are violating the students and their parents' civil rights. This is the level of insanity. This is the level of batshit insanity that we're up against, folks. And they use the courts to do it. And the courts so far have backed them every single time, in spite of evidence all over the 50 states of other programs that do not torture us, that actually work and are good treatments. This is what we're up against. All right, we will go ahead and close out there. And we are going to go ahead and wrap up for this morning. So we don't get very many views on this channel, especially on this topic. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button, hit subscribe, and please don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilly Tea hope you have a good one. Bye bye.